Great. Well, this is Howard Roth. I'd like to welcome you to our monthly government contracts webinar today on how to win your bid protest. I'm presenting today with Meghan DOURIS. Meghan has many years of experience in the area of government contracts and represents numerous companies in bid protests at the GAO and at the Court of Federal Claims. In fact, she had a defense of $100 million award that was successful in recent times. And Town is also one of our fighting government contracts protesters, and had a very interesting win at the Government Accountability Office concerning a solicitation for a manufacturer here in the Pacific Northwest. And I'm your host and chair of the government contracts practice group here at Olds, Morrison, Rinker, and Baker. And protests are booming. And we're going to try to give you a roadmap to success. Next slide, please. And we're going to stick to the basics. The first thing is you've got to figure out what is the best forum. Where's the best place to go? You know, lawyers always use the forum instead of place to go to win your bid protest, because that really is what it's all about. You need the work, and a protest is a way for you to get another bite at the apple, to get that work, or to make sure that if the government's taking corrective action due to a protest, that it's the corrective action, or if you see that there's a problem in the solicitation or something otherwise pre-award, to go to the agency. And really, you have three places to go. Everyone has heard of the U.S. Court of Federal Claims, which is pretty much the most involved place that you can go, and generally most expensive, and the Government Accountability Office, which is the most popular place. I mean, there are literally thousands of protests to the Government Accountability Office each year. Now, you don't hear a lot about agency protests, and that means you just go to the contracting officer or to someone above the contracting officer within the agency. And that's why I call it, like a secret weapon. A lot of contractors use that to their advantage, and it also has a plus that it also is the least expensive protest forum. We're going to talk about debriefings. Debriefings are critical. You want to maximize your debriefing, because debriefings, they exist in theory so that companies like yourself will not protest. The idea is that the government will explain their decision to award to your competitor well enough such that you'll understand why you lost, and there won't be a protest. But they also serve as a way for you to get the information, because you're not going to have a lot of information as to what the government did. And so every piece of information you get from the debriefing can allow you to get your nose in the tent, if you will, at GAO and file a protest, and it might lead to subsequent protests based on what you learn from the initial protest. The other situation is, shoot, you won the contract. You worked hard to put your proposal together. You had the discussions. You won, and now your competitor has filed a protest with the Government Accountability Office, and everything's stopped. And we're going to explain a little bit about defending your contract award. How you can help the agency, and how you can also make sure that the agency is doing the job they should to uphold the award of the contract that you've fought really hard to get. And then finally, talk a little bit about protective orders. One of the difficult things for clients in protests is that with a protective order, your lawyer is going to get to see all the information from your competitors, their prices and how they put things together, as well as everything that the government did, their internal emails, you know, their source selection decision, if there was one. But you as the client aren't going to get to see anything because it's all going to be protected. Only your lawyers can see it. And we'll explain that there's a real power to that because we can file additional protests and advocate on issues that you as a contractor could never do because you'd never be allowed to see the documents. It's also very frustrating because much of what you will see will be blacked out. So this is our roadmap to success. Pick that forum. Make sure you maximize your debriefing, and then defend your contract award if you're not the protester. Next slide. So in looking at the best forum to win your protest, you know, you look at the agency, the GAO, and the Court of Federal Claims, and you're sitting there. You see that there's a problem with the solicitation. Okay, you're challenging a solicitation. Where do you want to go? Do you want to go to the agency? Do you want to go to the GAO? Why would you go to the court? Because, you know, we know the court is, you know, it is more expensive, but there are reasons to go to the court. You know, one reason would be that the scope of discovery, you can get more information if you go to the Court of Federal Claims than you would at the Government Accountability Office. And for agency protests, you're going to get basically no discovery, which is, you know, an issue because it is the simplest form. You also have to consider, you know, do you want a hearing? You're not going to get a hearing at the agency, and the GAO very rarely has hearings. So if you want a hearing, then the Court of Federal Claims is probably the place that you want to go. Your opposing counsel, you know, at the Court of Federal Claims, you're going to have, you know, somebody from the Justice Department in Washington, D.C., a young go-getter, or, you know, do you want to have the you know, the agency counsel on the other side who's working for the agency out in, you know, the arsenal or the shipyard, who probably has a different approach to litigating than someone who's at Main Justice in Washington, D.C. One of the most important things that you look for, of course, when you're a protester is the stay of performance and award. And what does that mean? Well, if you file within the correct timeframes, and we'll discuss that, you can get a stay of the performance of the contract. So everything stops. You get an injunction, basically. If you went to the court, you'd have to get an actual injunction. At the Government Accountability Office, you get it simply by filing your protest. If you go to the agency, you can also get a stay, but it doesn't stop the clock running for you to get basically the mother of all stays, which is the GAO SICA, Competition and Contracting Act stay. As far as protest costs, again, it's going to be least expensive at the agency, more expensive at the GAO, and most expensive at the Court of Federal Claims. But you are going to be able to get your costs if you are essentially a prevailing party, if the government takes corrective action based on your protest, or if the Government Accountability Office actually sustains your protest, you'll be able to get a recommendation, which always comes through as generally payment of your attorney's fees. You're not going to get your attorney's fees at the agency, and there are more stringent rules at the Court of federal claims. Next slide, please. So agency protests. I like agency protests. I get criticism from some other lawyers, even in my own firm sometimes, because they say, well, what good is it really, Howard? You're not going to get the discovery information that you get in a government accountability office protest, and you're certainly, you're going to get nothing close to what you get at the Court of Federal Claims. But the thing is that they're inexpensive. They're very quick because you get a decision within 35 days, as opposed to the 100 days at GAO. The other thing is they're not revealed to any other, what's going on isn't revealed to, other offerors. So the decision isn't going to go to the other offerors. So it's, it's a way you can point maybe some things out, especially pre-award, that the government's done in the solicitation without forcing the government to air their dirty laundry. And again, there aren't a lot of downsides if it's a pre-award protest. So in other words, you've got a problem with the solicitation or some other pre-award issue, and you can just put together a letter. It would be similar to what you would file at GAO. And you could, you can also get a stay of the contract award and performance, just like you would get at GAO. However, it's not going to be as strong as at GAO because the agency is essentially reviewing itself. They don't have an independent party like the GAO or the court judge to decide. They decide their own protest. And if you could go back to, there you are. Oh, the next slide. There, you're perfect. So you can get the protest stay of award. So if you're doing a pre-award protest, there's not a lot of downside because there hasn't been an award made. But if you file an agency protest and an award has been made, and if you want to get that super stay of contract performance that would last for 100 days, then you would have to go to GAO. But sometimes I find that when you go to the agency, the dirty laundry is being, aired there. They may take a corrective action, and you don't have to go to GAO, and it's cost a lot less money. The risks, of course, if you go to an agency protest and it's not pre-award, it's post-award, and you wait the 35 days to get a decision, you'll get a quick decision, and you can actually continue to go to GAO and file a GAO protest, but you won't get that automatic stay that you get when you go to the Government Accountability Office when you file within 10 days of award, or as, and Meghan will touch on this, 5 days after a requested and required debriefing. So this is a weapon that is overlooked by a lot of contractors. There are, and there are, like I said, many lawyers who don't like it because you do have to be very cognizant of the time limits. Well, okay, they haven't gotten back to us. I still want that GAO protest automatic stay. So you may have to file your agency protest after award. And then if something hasn't happened within less than a week, then you're going to have to go to GAO anyway. But for pre-award, you don't have that issue when you're dealing with the solicitation. And so I think it's a very inexpensive way to resolve solicitation issues. I like this loose lips sink ships. It's secret. You're going to get the decision. The decision's not published. It's not provided to any of your competitors. Generally, the contracting officer will provide to those who are in, who have a chance of award. They will provide a copy of your protest. So, folks out there will know generally, what you have protested, but they're not going to know any of that interaction. The other thing is it allows us as your lawyer to call up their lawyer and talk to them, about our grounds of protest, again, without having your competitors in the discussion. I have seen just in the last few months, contractors file agency protests, get some more information, and it's been very beneficial to them, because information is power, especially information from within the government when you're trying to win a contract award. And again, money is, of course, important to all of us, and the attorney's fees are much lower for an agency protest, because what it really is it's a letter. It's your 10-page protest letter. The government then has 35 days to issue a decision. They're not going to give you a report on what they did like you get at GAO. You're not going to get any discovery like you might get at the Court of Federal Claims. But you are going to get a decision on the issue that you're concerned with. And so, while your lawyer can communicate with the government, there just isn't much beyond actually writing up the protest. What drives the cost up at GAO in the court are all the other additional pleadings, which Meghan will talk about, an agency report and briefing schedules at the Court of Federal Claims. And of course, you do get that decision in 35 days or less. The other thing about agency protests that sometimes is overlooked, like recently, Meghan and I did a protest with the Department of Energy, and it dealt with the Bonneville Power Agency, and the BPA has their own agency bid protest rules, and we also filed a protest under those rules. The Army Materiel Command has a very AMC has a very robust agency protest program where the protests are actually decided by an independent part of the Army Materiel Command, because otherwise your protest to the agency is decided by your contracting officer, of course, with input from their lawyers and from their other technical people. And so with this next slide, I will turn you over to Meghan DOURIS.
Hi guys. So I've been tasked with how to win at GAO and how to win at COFC, but I'd ask the question first, which is, what is your goal and what time frame are you in? Because that defines what you are winning, right? To win, quote unquote, what you need to prove, you need to allege and prove that the government violated a procurement law or a regulation and that you were prejudiced. And the question that's relevant to this is, are you pre-award or post-award? If it's a post-award, how do you do that, right? How do you determine what law or regulation was violated and that you were prejudiced? And Howard will discuss the debriefing process in depth later, but I'd say that the goal is to obtain, at least at GAO, your goal is to obtain as much information as possible, and in your GAO protest to throw as much crap against the wall as you can initially. Any possible cause of action that you can think of for your GAO protest is worth putting in your initial protest, because that opens the door to all of the materials and information that the agency has to disclose in response to that protest. You can use this process to then get information from the agency And then based on that, you can add even potentially more causes of action through the supplemental protest, which we'll discuss a little bit later, or you can use it to refine and take out what you think now, based on the information you have, are losing arguments. But if you do not make that argument initially, you're not going to get any discovery on it. You're not going to get any information from the agency. At GAO, the goal is to take advantage of the process and procedure. It is much less formal than the Court of Federal Claims. And you have to work within the timeframes and the process that's provided to you by GAO. If you are talking about a pre-award protest, that means you've gotten the RFP or the solicitation. You look at it and you can tell right off the bat there is something fundamentally wrong with that RFP or solicitation on the face of it. You must protest that before you submit your proposal. If you do not do so under the blue and gold case, you waive the right to protest the terms of that afterward. And this is something that clients often struggle with in my personal experience. They open the RFP or the solicitation, something doesn't seem right to them, but they don't want to raise any red flags, or for lack of a better polite phrase, they don't want to piss anyone off before they submit their proposal. If you waive your rights to make those arguments later if you lose. So you have to think about that thoughtfully when you initially get your RFP or solicitation. What is it in there that they are asking for? How are they intending to evaluate this? Is there some advantage that is inherent in the drafting of the language of the RFP or solicitation that favors the incumbent? And think about those issues initially. Raise any of those issues before you submit your proposal. And if you do not, you waive it. But you've already started to think about the preparation of your proposal from a critical standpoint. Now, post-award, the timing of a post-award protest can vary, and it varies depending on your agency, in that a protest that stems from a DOD agency has an enhanced debriefing schedule, which both Howard and I will talk about in a little bit, and that can vary when you have to file your protest. I have often advocated it is better to be dismissed as premature because you're dismissed without prejudice than to be dismissed as untimely. Because if you are untimely, that's it. The game is over. There's nothing else you can do. If you are premature, you can go back and take a second bite at the apple. Alix and I had a situation recently where the protest was actually not at GAO, but at the Court of Federal Claims, where we thought, because of the nature of the contracting program through the AbilityOne program, the incumbent contractor, knows that that a new contract is going to come out, and under the terms of that federal program, the very issuance of an RFP or solicitation, we argued, was contrary to the law. Eventually, Court of Federal Claims argued that no final agency action had been taken at that time we filed our protest. But the things that can happen as a result of that are either you get another bite at the apple, or oftentimes in response to a protest, without having to go through the formal procedure, an agency will take voluntary corrective action. So the filing of a protest can get you a few different results. And this goes back to, what is your goal, right? What is your goal? What are you trying to win? If you file this protest and your goal is to simply get a more fair or more accurate RFP or solicitation to be issued, that can often happen just in response to the initial protest, because a contracting officer can see the writing on the wall and doesn't want to expend any more time and resources going down that path with that solicitation. Or there's enough risk that whether or not they're positive or that they will win or lose, they will take some sort of corrective action. So that's, that's the process at GAO. Once you file at GAO, there's a time frame in which the agency has to make a motion to dismiss, and those are the jurisdictional grounds, right? They're going to say, hey, look, you contractor, you don't have a right to be here at GAO protesting this RFP or solicitation. Standard grounds are something to the effect of, this is an issue of contract administration. This is not a true protest. And you can see that often when existing contracts are out there in either an IDIQ or a list of offerers that have a potential, right, to a potential to obtain more work under that existing contract, and the contracting officer or the agency makes a decision to go with a smaller group of people or to factor in certain criteria in its process moving forward. Whether or not that is an issue of contract administration versus a protestable issue is something that would arise in a motion to dismiss. If you survive the jurisdictional stage, and I will say this from a practical standpoint, there are many that do not survive the jurisdictional stage. But if you survive the jurisdictional stage, then there is a process by which the agency issues its report, its response to your substantive protest arguments. Within 2 days of you getting that agency report. So, to say that it is a fire drill is an understatement. But within 2 days of getting that agency report, you can then request additional documents. You're trying to supplement the record. So the agency's made some argument in response to your initial protest, and you want records from the agency that support the arguments that they've made in their report. Then you get to do comments on the agency report. So you as the protester, and we sort of think of this like an opposition brief or something like that in the normal legal process, but you get to make comments on the agency report as to why the arguments they made do not undo your valid protest grounds. You get to do a supplemental protest. This is what I mentioned earlier, where if in response to the agency report and you request additional documents, you find out that you have additional grounds for your protest that were not raised in your initial protest, you then get to file a supplemental protest. And that process sort of starts over again as it relates to the supplemental protest. We all, as I said earlier, your initial strategy is to think of every possible argument that you can make and throw it against the wall to see what you get from the agency in response to that. You have an opportunity to evaluate your arguments. If there is something that is clear in the documents produced by the agency in the record that you feel that argument is no longer a strong argument, or perhaps it detracts from some of your stronger arguments, you have the opportunity to drop those weaker arguments before the record closes. And there are times, I've gone through this process with clients. We've gotten the debriefing. We've gotten enough information from the debriefing that we feel we have a strong enough ground to make a protest. We've gone through with the protest. The agency's filed its report, and there's something in the agency report that calls out to us that a step was missed in the RFP, in the proposal, or the arguments that we thought based on the others, because you as a protester, right, you have this opportunity to make these protest arguments. A lot of it's on your initial gut instinct. You think your competitor doesn't have the requisite key personnel, or you think that they don't have the requisite background sufficient to have met the past requirements. So you file a protest on that. When you get the other side's proposals, and Howard or Alix will go into a little bit later who gets to review what, but as counsel, I get to review all of the competitors' proposals. I may be able to say, hey, look, I know we thought this was an argument. It turns out when I look at their resumes and or their CVs that were attached to your competitor's proposal, they do meet the requirements. You can be prepared to cut bait in terms of either dropping the entire protest if you need, or dropping, and remaining, which is maybe your one strongest argument. And I'll give you a little bit of statistics. Howard was talking in general about whether to protest at GAO or the Court of Federal Claims. In 2020, in a year in which we were largely shut down, there were still 2,149 protests filed at GAO. 545 of those were decided on the merits. So when I mentioned earlier that there's a lot of protests that get dismissed on the jurisdictional grounds, that's where that gap comes in. So roughly, give or take some number, 1,500 or so of the protests were dismissed on jurisdictional grounds or voluntarily withdrawn before they were decided on the merits. Of the 545 that were decided on the merits, there were 84 that were sustained, and there were, I was just going to pull up the stats one more time. There were 84 that were sustained in 2020, and overall the effectiveness rating was 51%, and that is the first time in many years that the effectiveness rating has climbed above 50%. So when you are weighing your options, GAO is generally believed to be more favorable to a protester than the Court of Federal Claims.
Megan?
Yes.
We have a question. The question is, if you protest after the award and win, what are the chances the award will be set aside and re-awarded to you?
In my personal experience, I have seen, so can you say that one more time, Elise? I'm sorry. Or actually,
no, it's fine. It's if you win your protest, what are the chances that you actually get the contract?
Oh, it depends. It depends on how many other people have protested. Are there other interveners? If the government agency has decided in the interim to issue some sort of corrective action, even if you've been awarded you've won. So if you win at GAO, you are correct, right? You have shown the government successfully that they have violated a procurement law or regulation. You don't automatically win. You don't. The other competitors are not disqualified, and you don't get the contract. The solicitation or RFP is reissued without those violations of the law or regulation. If you are successful, you are the successful awardee, someone else has come in and protested that, and their protest is denied, you as the successful awardee get to keep your contract. If you are the successful awardee, someone else has come in and protested and their protest is sustained or they win, you are no longer the successful awardee. The contract is recompeted 99.9% of the times. Sometimes the contract just disappears altogether. I've seen that happen where the services are either reallocated or redistributed or something to that effect.
And we don't, just to add to what Megan was saying, there aren't statistics about how often the protester actually ends up with the contract. The government just doesn't keep track of that.
Correct. Nor does COFC, the Court of Federal Claims, keep track of it in that fashion. In the interest of time, I'm going to skip over the demonstrative, which was kind of a timeline, because at the end of the day, what you really need to know from a GAO perspective is it's 100 days from the day you file. There are some routes that you can take to get there, and there are some paths that can deviate based on the debriefing. And now with the enhanced debriefing by DOD, that path can change even more. So at the moment, what you need to know is you're going to file. Within 30 days, you're going to get the agency. What happens after that depends on if there's supplemental grounds for a protest, but eventually you're going to get a decision within 100 days. This, I will tell you, is the picture perfect example of way too many words on a PowerPoint slide. Do not try to read it all now. to even present on these topics alone would be its own 90-minute presentation. But what I would say is this is an example of a checklist to keep that you can use when you are in the process of preparing a proposal, or you've gotten an RFP or solicitation and something just doesn't seem right. You can back check against this list. But these are generally the gamut of the categories that one would use for a post-award protest. The pre-award protests are 99.9% of the time, that solicitation or RFP is in violation of a clear procurement law or regulation on its face. There is something in that RFP or solicitation that, just it is contrary to the law. I would say I don't actually know the breakdown of the pre-award versus post-award solicitations, but the bulk of bid protests fall in the post-award category. All right, next slide. Next in the process, okay, is you've made a choice for the reasons that Howard identified earlier to not go to GAO, but to go to the Court of Federal Claims, or you went to GAO, you didn't get the decision you wanted, and now you're going to take it up at the Court of Federal Claims. The Court of Federal Claims can either be your initial venue or your sort of second bite at the apple. Why are you at the Court of Federal Claims? It could be that you weighed your options and this seems like a better venue for you. Could be you blew some sort of timeline. The Court of Federal Claims does not have the restrictive timelines for filing a protest that is in place at GAO in technical terms. There is no written rule at the Court of Federal Claims that says you must file within 10 days. Practically speaking, more often than not in a protest, the Court of Federal Claims will look at and refer back to GAO's rules and regulations in making its determination as to whether a protest is timely. The difference between the Court of Federal Claims and the GAO is that the Court of Federal Claims resembles more of a traditional lawsuit. You do not file a protest with all of your arguments up front and all of your factual. It's not written like a long letter or a long brief. You appear in the Court of Federal Claims with a well-drafted legal complaint with identified, and I will say this, thoughtful causes of action. And I say it that way because a lot of times bid protests are sort of thrown together at the last minute, complaints filed at the Court of Federal Claims in sort of its barest terms, because that's really all that's required of you. But that is what the DOJ attorney will refer back to in A, determining what the administrative record should be, and B, in making its legal arguments to dismiss your protest. The difference between GAO and the Court of Federal Claims is, so at GAO or at Court of Federal Claims, you're going to file your well-drafted legal complaint, but there is no automatic stay. So you have to determine whether or not you need a temporary restraining order to try to stop that procurement from going forward. I will say, at least probably 75% of the time, I have been able to get the Department of Justice attorney who is assigned to the case to get the agency counsel and the agency involved to voluntarily stay the action for a certain period of time. And that is then presented to the judge. And the judges in my experience have tried to endeavor to work within that time frame such that a decision from the court can be issued during the time in which the agency has agreed to voluntarily stay. And you kind of get this little gap period because before you file your complaint at the Court of Federal Claims, you've got to file a notice of intent to protest. And that goes to DOJ and the clerks at the Court of Federal Claims. The clerks then determine which judge has availability to hear that matter. DOJ counsel will then reach out to you and say, hey, I've been assigned this case. let's talk. DOJ, in my practical experience, doesn't not want to start a case by responding to a TRO order. So they will work hard to get agency counsel to voluntarily stay. If agency counsel does not agree, your standard to get a stay is that you have to, one, prove that you are likely to succeed on the merits, show irreparable harm, and irreparable harm cannot just be dollars. Money is kind of a tricky issue, right? Because if it's just bid prep costs or attorney's fees or whatever the case may be for preparing a bid document, those can be awarded to you if you're successful on the merits. So simply spending money to go after a flawed solicitation or RFP is not irreparable harm. You have to show a balance of the hardships. You as the contractor are more apt to be harmed by this going forward than the government is, and you have to show it's in the public interest to stop a procurement process while this protest goes forward. And I would say, practically speaking, why is this difficult? And that's because you have very little information in front of you at the time you have filed this TRO, right? You filed, the protest went, or the solicitation or RFP didn't go your way. You now want to file a complaint, but you may have gotten some information in the debriefing, but you don't have a ton of information. And so to prove that you're going to succeed on the merits without having the record in front of you is a difficult hurdle to leap over. In general, winning your protest at the Court of Federal Claims really requires you to push, and I would say push the boundaries of it, right? You get this administrative record. The administrative record should be all the documents and information that the contracting officer and the source selection personnel had to make their decision when they made the award. And a lot of times I will tell you that is not what you get in response. You are entitled to additional depositions or written discovery under certain circumstances. You have to, it's an uphill battle, but you can get them should you make the motion. So at the Court of Federal Claims, I would say you have to be more aggressive in pushing back against the agency and pushing back against DOJ. In general, you know, there are a set number of judges appointed to the Court of Federal Claims. They're there for 10-year periods. The court only hears they have a very limited federal procurement world and vaccine cases. So it's fairly easy to get a list of decisions from your judge. They're easy to locate, and they're well worth studying. Each judge in the Court of Federal Claims always has sort of a unique sort of pet peeve, I would say, or a unique area that they like to focus on. You want to make sure you're not making the same mistakes as other attorneys have made, and you want to make sure if their issue is how well a case is pled or what the complaint looks like, then you go back and you amend your complaint. You make a motion to amend your complaint. If their issue is, you know, they really focus on standing or jurisdiction, you want to make sure that in drafting your motion that you do so. And so here, instead of an agency report in your initial protest, you make a motion for judgment on the administrative record, and you make all of your arguments to the court as to why you are right and the government is wrong based on the administrative record. The government then responds with its cross motion to dismiss your case and its, you know, opposition. So they kind of get 2 bites at that apple. You get one reply brief / opposition to theirs, and they get another reply on top of that. The court will then either hold oral argument or simply issue a decision. In the past, I would say I got oral argument on almost every case in the Court of Federal Claims. Lately, that has not been the case. The court has talked about setting up times for oral argument, and then all of a sudden a decision has been issued. And I'm not sure if that's simply due to the Zoom COVID era, and they simply don't want to disadvantage people with oral argument in Zoom mode, or if this is more of a strategy switch at the Court of Federal Claims in general. It will be interesting when the world reopens to see what direction the court takes that. Next slide, and I'm going to turn it back over to Howard.
Howard, you're on mute.
I muted myself. You mentioned about the 51% effectiveness rate. I think that's really remarkable that it went over 50% at GAO. You know, it's hovered slightly below 50%. And, you know, I think for a contractor, and going to that question that you had, it basically means that 50% of the time, either the protest is sustained, or after the protest is filed, the government decides we're going to take corrective action. We're going to do something in response. You know, the protester has raised something that we need to address, and then they don't file an agency report. One of the things is at GAO, as we talked about, you can get your attorney's fees, which again, costs are always important. If the government goes ahead and files an agency report and a protest is sustained, then you're going to get your attorney's fees on those portions of the protest that were sustained. By not filing the agency report and taking some type of corrective action based on your company's protest, then no agency report is filed, and then the government doesn't have to pay the attorney's fees that were incurred generally in filing the protests. So that 51% effectiveness rate means that 51% of the time, the government's going to have to essentially do some type of reevaluation that allows the protester to be considered for award again. Just segueing into the debriefing process, the debriefing is key for the protest. And I know there was a question, and I think Alex was able to find the questions, and so I finally found them too. I thank you, Alex. There's a question that says, maximize the debriefing. Government generally makes a point of offering almost nothing during a debriefing. Most questions garner the response, we can't divulge that information. What do you mean by maximizing? Well, the first thing that you want to do is you want to go to FAR 15.506 and have that, in front of you at the debriefing, and make sure that they tell you, hey, significant weaknesses or deficiencies. The FAR says you're supposed to tell me them when you know, and then take copious notes as to what their answer is. The same thing goes with your evaluated price and technical rating when one's developed, and the awardee. You want to make sure that you get that information, or if they won't give you the information, to write down exactly what they say, as well as the overall ranking for award. The reasons for this is, if you go back to that slide, after our presentation, because I know you guys are going to be also excited about protests that you'll be looking at it, that one that had more information than you really should have on a slide. You want to try to either get a fact that's going to key into one of those protest grounds that are in bold on that slide, or you ask the question and they wouldn't answer, which would be, well, gee, they wouldn't tell us if they had complied with this, or this, that leads to a protest ground. So basically, I hear you. They want to say, well, we can't tell you anything. We can't tell you anything. Well, I mean, find out what they'll tell you about your significant weaknesses or deficiencies, and then, well, no, that's not a weakness or deficiency. Get them to say something, and they've got to tell you the things that they're required to tell you. The overall evaluated cost or price, technical rating, and the best value if it was developed, the overall ranking of the, for award, and then you'll ask them, did you do the cost technical trade-off at section M? I mean, they got to say yes or no. I mean, if they won't answer that, then I mean, you got a good protest ground there. They wouldn't say that they did it properly. Taking them through the source selection process, or what the solicitation required, and just asking them, did you do this or not, is going to be helpful, because if they won't answer that, then they're going to open the door up to a protest. The whole reason that we have the debriefings, I mean, the reason for debriefings, it's supposed to be a conduit under 15506, and 15506 is for post-award debriefings. There also are separate rules for pre-award debriefings, you know, like when you're excluded from the competitive range, and that's 15506. But the idea was that the government would share with you enough information, and that the government would know their award decision well enough to be proud to explain why they went with the best value to the government, such that you won't protest. So you want to just get any information. You know, the key strategies are, of course, to request that debriefing as soon as possible. You know, you've got 3 days to request a required debriefing, but you want to get it in there the first day. You know, request your debriefing, study that RFP or evaluation criteria and your proposal for your questions. And since they're required to give you reasonable responses on that RFP process, if they don't, that's going to help you with your protest. You know, look at that, you know, at that slide that has more information than you really should have for somebody like myself who wears glasses, because those are the issues that year after year lead to successful protests, and you want to try to get any of that type of information in your debriefing. Now, don't argue with the agency. Generally speaking, in doing protests now for 30 years, I have only attended one debriefing for a client. It's generally, you don't bring your lawyers with you. It tends to freeze the government up, and it allows information, I think, to flow better. So don't argue it with the agency at the debriefing. Just be polite and nice. If they say something, you know, that is just wrong, don't try to. That's great. You've just you know, hit the pinball machine and gotten 10,000 additional points because you've gotten them to show that they made a misstatement. Next slide. And drum roll. Now, DoD enhanced debriefings. Meghan has she had just written an article on this. I don't know if you want to take it, Meghan, or this issue came up with something that we worked on in December when this case was bubbling.
Sure. So there was some confusion. Most people are aware by now that DoD recently changed its process and procedures, recently being a relative term in the past few years, but to provide this enhanced debriefings. And essentially, you get a debriefing from DoD, you get 2 days to ask supplemental questions based on the debriefing you got, and the government has to answer them. There's a couple of tricks that come in with that, but the Court of Federal Claims threw a curveball to everyone last year in April. They issued a decision essentially changing when the clock started. So last April, the Court of Federal Claims in the NECA case decided that regardless of whether or not you actually used those 2 days and asked supplemental questions, you got the benefit of those 2 days for the purposes of a sick stay. Everyone was very surprised by this process, but it definitely threw a curveball into what and when did that clock start ticking in order to file your protest for a sick stay. We, of course, were advising clients to, while the Court of Federal Claims may have said that, to err on the side of caution and stick with the 5 days if you did not ask questions. The Federal Circuit came back this spring and overruled the Court of Federal Claims and said, no, you only get the benefit of those 2 days for the purposes of the clock if you, in fact, submit written questions. If you do not submit written questions, you do not get those 2 days. But where the confusion comes in is, when does that debriefing close? What does it mean to close, and when does it close? And what we have advised clients is, if you have asked questions and the government has not, in fact, provided answers to all of those questions, they've informally told you they'll get back to you, they'll provide you more information, to CYA and follow up in writing and say that it is for your understanding that the debriefing process remains open until such a time as you get the agency's responses to your outstanding questions. No one wants to waste money and get in an argument at GAO as to whether or not you even have a right to be there or whether you've blown a timeline. So we've just said, you got to pay careful attention to those timelines. And really, honestly, there should be no reason that you don't ask supplemental questions. If you have the opportunity after your debriefing to submit written supplemental questions, take advantage of it. Like Howard was saying, they're not going to do a point-by-point comparison. They're not going to say company A is better than you for the following reasons on its proposal, but they do tell you what your weaknesses and strengths were. And if you do decide to go forward with a protest, your counsel does get the proposals from the other side, and you can see and compare whether or not what they told you were your weaknesses were in fact the same weaknesses exhibited by your competitor who was successful. So it's like Howard said earlier, information is power. Use the process to get as much information as possible, commit as much of that as possible to writing so that you can use that information when you go forward with your protest. Go to the next slide.
Megan, before we move on, we have a question, which is there a dollar threshold for the enhanced debriefings?
There is a dollar threshold. Howard, do you know it off the top of your head?
No, we can, there is a threshold. I'm just not sure what the.
I'm not either. I will type the answer to you in the question box. There is a dollar threshold. I'm just off the top of my head. I'm not sure what it is. I've never run into it where it's been a determination where it's processed whether or not we can go forward, but I'll type you the answer.
Okay, so discussing debriefing strategies here. There are a couple of potential traps in the debriefing process. First, you have a limited time in which you can ask for a debriefing. It's generally 3 days after notice of award. Now, the best practice to get into is you've been notified that you're not going to award, just send an email back immediately asking for a debriefing. If you end up deciding you don't want it, you can always cancel it later. But what you can't do is come in on day 4 and say, I would like a debriefing, and the government says, sorry, you're too late. Then Howard discussed the time frame for the CICA stay and when that applies, so I won't go over that again, but pre-award debriefing. So if you've got a procurement that has a competitive range determination and you get eliminated at the competitive range stage, you can always request a pre-award debriefing. You don't have to. So there's some tricky things about that. If you want to protest your elimination from the competitive range, then you can do that right away. But you can also gamble, wait to see who's been awarded the contract and come back and say, wait, I think there was a problem with the award. It should have gone to me instead. It's tricky, it's risky, not the best way to do it, but you do have the option to actually wait for your debriefing to the end of the whole procurement. You don't have to do it at the competitive range stage. So some myths. I shouldn't request a debriefing until I have a reason to suspect that the agency did something wrong. Debriefings aren't just about generating protest grounds. They're actually really helpful ways for the government and contractors to communicate about how to make a better proposal. So at the end of the day, it's actually best to ask for a debriefing and to come in and say, okay, tell me how we can do better for next time. It builds the relationship with the government while at the same time allowing you to gain valuable information about how the process worked. If during that debriefing discussion you realize something went wrong, that gives you the opportunity to address those issues. I should use my debriefing to let the contracting officer know exactly what I think of his or her decision and convince him or her to change the award. That is very unlikely to happen. So again, it's going back to you're going to meet your customer at the end of the day. This is a conversation with your customer. So it's important to go in with it with an open mind to receive information rather than to transmit personal opinions. And Howard discussed having attorneys at debriefings. It's interesting, originally with this enhanced debriefing process, gosh, about a decade ago, the Air Force was doing enhanced debriefings where the attorneys were the only people allowed in the room. They were allowed to come in and actually review source selection information subject to protective order and agreement not to disclose. That's not what they're doing. So attorneys generally don't help the conversation. What we can do is we can help you prepare questions in advance. If you think that there's something wrong, call us and we can discuss what the legal principles are and what questions we need answered in order to help you further a future protest, or come back and say, okay, the agency really did do it right, and here's how I better my proposal for next time. I can protest the agency's failure to provide a required debriefing. Nope, can't do that. So next slide, please. So Howard brought this up earlier, interveners. It's an interesting concept. You have won the contract and you find out that there's a protest. In some state procurement processes, actually, you are required, if you're going to protest, you're required to bring in contract awardee into the lawsuit. Federal government said, nah, we're going to let interveners decide if they want to participate or not. And sometimes it's a good idea. Sometimes it's not necessarily the best idea. It's definitely a case-by-case basis, but why would you want to? Well, one, if this is a really big procurement for you, you want to make sure that the government is making the best possible arguments to maintain the contract award, and you get an opportunity to have your say about why your proposal meets all of the requirements. Nobody knows your proposal like you do. The government has evaluated it, but you know it inside and out. So the real benefit of going in is you can provide a lot more context and detail than government counsel can. And keep in mind, the people that are writing the actual briefing, either to GAO or the Court of Federal Claims, they're one step removed from the process. They are counsel to the people who reviewed the different proposals, whereas you guys know it inside and out. So it's very helpful to come in and say, hey, let us help you and let us give you the substance so that you government can go in and defend this thing. And you don't always have to intervene formally. You can actually come in and say, hey, do you want some help? Here's some information that we have. But sometimes it's worth it also to come in formally and say, hey, here's GAO, Court of Federal Claims, here's what I want you to know about my proposal and why it's the best one. It also helps you in some ways help shape, if the agency decides to take corrective action, you know what it is in advance of everybody else, and it can help you kind of, if you get the opportunity to revise your proposal, it gives you a bit of a jump start. Next slide, please. So what's the process? If you wait to jump in until the comments are officially due, it's a little bit late because you haven't had the opportunity to help the government shape their argument. So early intervention is probably the best policy, but the actual steps that you go through is you will file your briefing after the government at the same time as the protester at GAO. So as we've discussed before, protester files a protest, then the government provides their comments, or I'm sorry, their agency report, and then the intervener provides comments in addition to the protesters. The protester is going to say all the reasons the agency report's wrong. You have the opportunity to come in and say all the reasons the agency report is right. You also have the opportunity to review the record to see if there's a reason to dismiss the action. And I think we discussed this before, is helping the government, whether you formally intervene or not, can be really helpful. Next. The Court of Federal Claims, so Meghan described this. There's the motion for judgment on the administrative record, which the protester files. You as the intervener will file at the same time as the government, the opposition. And then you will also get the supplemental reply after the protester's reply. And it's 2 briefings to the court as to why what the agency did is correct. They don't have to be identical. And again, you can provide more information. The one thing to know about intervention is that the intervener's counsel is subject to the same protective order restrictions as a protester's counsel. So your attorney can see everything, but you as the client won't be able to see everything. So in that sense, it's a little bit of a black box for you in addition to the protester as to what's going on. But again, you're going through and you're talking about your proposal, which you are the expert on. So next slide, please. And I'm going to turn this back to Howard.
Yes, and we had a question, and that question was, let me just see here as we go down. How can you avoid agency retaliation, bad evaluations, unjustified complaints, etc., if you win a protest over the agency's favorite? Well, as Alec said, you are going against, if you will, your customer. And what I always tell clients is that our protests are going to be measured. We are going to make sure that we do drop, or we would recommend, drop arguments once we know from the agency report or through other information, that they don't have merit, and just to make sure that the opposing counsel, whenever I talk to them on the phone, and I do try to call up the agency counsel and talk to them, knows that this isn't personal, it's business, and if that's communicated properly, then it really isn't an issue. Having been in the government advising contracting officers for 20 years, it's the protesters who sort of go off the reservation or make arguments that have absolutely nothing supported by the record and won't drop them. They're the ones that have things, I wouldn't say held against them, but certainly the agency has a memory of how you comported yourself. So it is tricky. You're filing a protest. You don't want to upset your customer, so you just sort of have to do it in a polite, sincere, and reasonable manner, and that you have to rely a lot on your attorney for that. Our final, issue, of course, is protective orders, and it's something that a lot of clients have difficulty with. So it's really the key to winning protests, because your lawyer at the GAO or the court is going to get to see how the sausage was made by the government in your procurement. And one thing that we mentioned at the very beginning, and I'll say again, a lot of times it's not your initial protest that you filed when you didn't have a lot of facts, but it's your supplemental protest that you file after you get the agency report or discovery that is sustained or that requires the government to take corrective action. And the only way you find out about those supplemental grounds is because your attorney has been able to see all the source selection information, what the other companies put in their proposals as far as, say, pricing or technical. So it's a very powerful tool. Certainly, there's no rule that says a company can't just file a protest without having an attorney or an attorney admitted under a protective order, but it would greatly diminish your chance of success. And it's rarely seen, and it's almost never successful And that's important when you look at the 50% success rate, if you will, of some type of corrective action on when you look at all protests that have been filed. But it is going to be frustrating to you as a company or a client, or even our dealing with the in-house counsel that hire us, because what you'll be able to see that's going on at the GAO or the court as far as filings is going to have lots and lots of blackouts. Well, here we are at the end. We've answered some questions. I want to thank you for your time, and if anyone else has any other questions, please let us know. Send any of the three of us an email, Megan, Alix, or myself, or there's time for you to ask a question. I see that there may be one. Does the FAR, here's a question, does the FAR have provisions protecting protester against retaliation? There's no FAR provision that says that, because it's just a basic tenet that the government's supposed to provide you with good faith and fair dealing. That's about the only way I can answer that. Any other questions? Oh, it looks like there may be another one. No. Oh, we just answered that. Okay. Oh, Megan is gonna answer, or at least that's what I saw. Were you going to answer, Megan?
No, I just I answered it live, and now I have a terrible feedback, so I'm definitely not going to answer anymore. Generally, what I would say is, in furtherance of that retaliation notion, it's an impossible question, and it's an impossible application to both understand, and it's so personally dependent on certain contracting officers. We have certain clients who protest, who serve only one agency and may protest 10, 11, 12 times a year. It has not prevented them from being a successful awardee. It's just the nature of the competitiveness of that particular market. There are other federal agencies that are not as familiar with protests, and I would say I've run into certain contracting officers that do take that personally. To prove retaliation is almost impossible. I have been involved in a protest where that argument was made. I was the successful awardee. We intervened into the protest. The argument was made that they were being retaliated against by filing agency protests, and then the Court of Federal Claims protest, and the judge just dismissed that argument because there was simply no way to prove or establish that.
And some of the time you look at it, another argument you can make is that you're being de facto debarred. But in order to do that, you basically need a statement from the agency saying, we're not going to award to this particular person anymore by someone other than a suspending or debarring official. So it's very, very difficult to prove, and you'd have to be given that in discovery by the government too. So it's unlikely to be successful.
Well, thank you, Alix, Megan, and all of you who've listened in. If you have any other questions, please contact us. Have a nice rest of the day.